other partner organizations really wanted to pursue it, is we know that when people are more self-determined, when they're more in charge of their day-to-day decision making, there is evidence they are healthier, they're more independent, they're more well adjusted, and they're better able to recognize and resist abuse. They actually are safer. And I think that flips this idea of guardianship on its head, because a lot of people think, well, I need guardianship to keep my loved ones safe. I need guardianship to keep them from making mistakes. Guardianship doesn't actually protect people from those things. It is a legal decision-making process, but it can't really protect someone. On the other hand, there is evidence that greater self-determination, empowering the person to be more in charge of their life and decisions and providing more confidence to them, is actually what is able to keep people safe. So here's just kind of a glimpse of what that supported decision-making agreement looks like. This is the law required the Department of Health Services to create the form. So this form is up on the DHS website. If you haven't seen this form and you just want to Google Wisconsin DHS supported decision-making form, I believe it comes up pretty easily. So you'll see, I've got it in front of me too. I know you're just seeing my screen, but it literally is a form that is 1, 2, 3, 4 pages. So 2 pages front and back in this sort of like 14-point font. So it's not too complicated. And here you're seeing that I, as a person with a disability, am designating a supporter, and I'm naming that supporter. And then I am very clearly delineating the type of decisions that my supporter can help with. And if for some reason I don't check a box on here, it's determined that no, I haven't given permission to this supporter. It also gives me that box at the bottom of other specific decisions that I might want the supporter to help me with. And then the rest of the form is saying that my supporter can help me collect certain types of records, medical records, financial records, education records. Again, I still have to use any required HIPAA or other forms that are required under other laws. This does not trump that. And then I can also choose that my supporter can help me understand options, help me communicate options, and then there's a date that I sign, and then it has to be witnessed by 2 people, and statement and signature of witnesses, or signed by a notary. So, and that's it. And so depending on who I want to know that I have this supporter, that I've given permission to this supporter, I would provide a copy of this supported decision-making agreement to my case manager, to my special education transition teacher, to somebody at the bank, so that they can also have this on file. I have Erica, my daughter, has an agreement. I have it scanned in my phone and I'm able to email it, and the hospital has it on file. The school has it on file. So that's how people are using this form. So people who use supported decision-making agreements, there's a definition in the law and on who can use them. Anyone can use the concept of supported decision-making. And again, we in our regular daily lives, all of us use some kind of supported decision making, whether it's somebody that's supporting us to do our taxes, or somebody who's supporting us maybe to look for a new home, or in other sorts of complicated decisions where we don't have expertise. We're using a variety of different types of supporters, so anybody can do that. But for people with disabilities who want to use this formal process so that they have a form that gives people permission to support them, we've defined that in the law. And it's really very general. People with functional impairments, people of any age with a degenerative disease. So think of somebody, oh, can you hear me still?
Yes.
Okay, good. So think of somebody with dementia or some other declining sort of a disease as they age, people with any condition that interferes with their for self-care, physical disabilities, intellectual developmental disabilities, mental health concerns. And that definition of functional impairment was taken from some other place in the law, so it's pretty standard. With regard to schools, you may or may not be familiar that in the law, schools are very specifically called out. And I'm going to see if I can find it in the law. Let me see. Yeah, I would read it to you if I could find it. And I know it's in here, but anyway, schools are so when I say other alternatives, it's that chart that talks about standard pathway to guardianship. The law also talks about how when someone is before the court, that the judge has to ask whether other alternatives to guardianship have been tried and whether less restrictive means, including supported decision-making, could be used. So if someone goes before the court and they haven't really done these things, it's possible that a judge might say, hey, go back to the drawing board. You really need to have supported this person with more practice in decision making before I will basically take their rights away. And a supported decision making agreement can't be used as evidence of incapacity. So it's something that was really important to the authors, that just because somebody needs a supporter doesn't mean that they are that could be used to say, well, they really aren't very capable to participate in their decisions. So how can a supported decision-making agreement help people? I think I've certainly heard stories of folks where if the child doesn't have a guardian by age 18, the parents then might be excluded from an IEP or important transition meeting or meeting with DVR, and having that supported decision-making piece of paper or agreement on file when the child turns 18, if the parent is the person who's listed as supporter, or maybe it's somebody else, that person then can help in that transition planning. Again, as I mentioned, under the new law, schools are required to provide students and parents on information on supported decision-making. So it can also be used to ensure that supporters can attend other types of meetings and gather that information. So it could be in terms of long-term care. Maybe if somebody's in IRIS, we're gathering information about potential employment vocational providers to give the person some idea on who they might want to include in their IRIS plan. And then that supporter can be somebody that walks them through those options. And then again, being able to communicate that person's choice, like if there's somebody who's difficult to understand, or maybe again, if it's somebody with who is nervous in meetings and doesn't want to participate in that way, a supporter can provide that role in a meeting. So supported decision-making agreement can help ensure that the person is clearly understood, and that person who might have challenges with speech or sign language communication devices might be somebody who could really benefit from using a supporter. So my daughter, she is nonverbal. She does use a communication device, but sometimes she doesn't like to. And when she goes into the hospital or to the dentist, she was just in the dentist the other day, she is just too nervous, doesn't really want to be there or communicate, but she knows that she has to be there in order to get her teeth fixed or her eyes checked. And we have those conversations the night or days before, and then my husband and I can step in as her supporters at those visits and help her to get all the necessary paperwork and permissions signed.